It's a historic decision, and I think the first thing that I'd like to say is that I congratulate the entire nation because ultimately the constitution has won. What the Supreme Court of Pakistan has said in summary is that if any provincial or national assembly is dissolved, then certain consequences follow. If a provincial assembly is dissolved by the governor, whether on the advice of the chief minister or because there is a vote of no confidence against the chief minister, then the governor is to announce and give the date of the elections, which cannot be more than 90 days from the date of dissolution. If, however, the assembly is not dissolved by the governor, but it is dissolved, for example, the term ends after 5 years, or it is dissolved under Article 112 because the chief minister has advised and the governor refuses to heed that advice, and after 48 hours the assembly is dissolved. In both these situations, because the governor has not ordered the assembly to be dissolved, then under section 57 it is the president of Pakistan that will announce the date of the elections, of course with consultation of the Election Commission of Pakistan. But the underlying condition is that the elections have to be held within 90 days. Now, keeping this legal position in mind, what the Supreme Court has said is that in the case of Punjab Assembly, because the governor did not dissolve it and the assembly was dissolved by virtue of a flux of time, therefore the president under section 57 was right in announcing the date. And the order of the president is confirmed. So the elections have to take place on the 9th, unless the president changes that date by a few more days, keeping in view the delay that has happened as a result of all these litigations. As far as the KP governor is concerned, because he dissolved the assembly, he accepted the advice of the chief minister and dissolved the assembly. Therefore, he must announce the date. And the president's order in respect of KP is wrong. The date cannot be announced by the president, but by the governor KP in consultation with the Election Commission of Pakistan. So the governor KP has also been directed, therefore, to announce the date immediately so that the elections can be held within 90 days. Now, an argument was raised also in the Supreme Court of Pakistan that the finances are not available, the security arrangements are not there. So the court, keeping that in mind, has also directed the federal government and the caretaker governments of the two provinces to ensure that the funds are available to the ECP and the security arrangements are given to them to ensure that the elections are conducted. This is the majority judgment of the 5-member bench. So 3 judges decided this. 2 judges, however, dissented, but their dissent is a minority view and therefore not a decision of the Supreme Court. Under the law, the decision of the Supreme Court is always by majority. But in their dissent note, they did not touch the merits. They just said that the matter should be decided by the high courts before whom the cases are pending. And they should decide first, and then if necessary, we can decide in appeal. But that minority view is now not relevant. It is academic. The decision of the Supreme Court, the 5-member bench, is the decision of the majority, which I have narrated just now. The only way this verdict can be challenged is there are many judgments of the courts which are 3-2 or 3-1 or 5-3 and different permutations and combinations. But the only way you can challenge the majority judgment is by filing a review before the same bench that decided this matter. So the government has an option of filing a review if they are aggrieved by this, but it will be heard by the same 5-member judges. Now, I heard the Honorable Law Minister on TV channels, and he was talking about the fact that there are two judges who recused themselves, who were not part of the bench, but were part of the initial bench of 9 judges, who have also said that they do not want to hear this because they think that the suo motu proceedings should not have been taken. Now, the law minister was saying that their judgment should also be included as part of the judgment of this bench, but that is an absurd argument, because they were not part of the bench that heard this matter and decided it. They, in fact, initially, when the 9 judges sat together, they said these two gentlemen said we don't want to hear it, and 2 other judges also recused themselves, saying that we have already given our view that the suo motu is maintainable. But all those 4 judges never sat or became part of this 5-member bench. So the decision that is effective and binding on everyone is the 5-member bench decision.